Hi, Dennis. Um, how many participants are we supposed to have for patent?
I'm sorry, you said we're expecting about 10 people in class today. Um, okay, moving on. Good evening, everybody. Thank you guys for joining in. Thank you, Esther and Tony, for joining in. Please, I would like to kindly encourage us just before we start. So please drop a reminder in the hmm, to drop a reminder in your subgroup, letting your comments know that we are starting with class or we have already started with class. Right. Thank you very much. So thank you to Miss our mentor, Miss Shukurat. I can see she's already on call. Thank you, Ma, for joining us. We are happy to have you in session today. So moving on, we are still announcing about the JIIPCC Academic Illegal Clinic, right, for creatives, entertainers, athletes, innovators, and startups. We want to give them the opportunity to get a 20 minutes consultation slot with our professionals and also get an opportunity to review their contracts if they have one, right? This is the link for the registration. Also, this is the link for the registration. Also, please, I would like to kindly encourage you to reach out, share the word to someone, tell someone that this opportunity is available, so that we can have people take advantage of it. Yes. So moving on, just by way of continuity, right, and by way of what we do every time, we would just like to introduce our mentors for today, Ms. Amosa Shukurat Modupeola. Thank you so much, Ma, for joining us. We are happy to have you in class. It has been an honor so far having you help us with sessions and take us through each week. And the experiences we have in each week, we are sincerely and truly grateful to have you with us in class again today. So next, which we're not sure, or we have not been able to confirm his availability also in regards to today's class is Mr. Rakesh Sharma. I don't know if he will be joining us today, but if he does, it will be nice also learning and hearing from him. Um, so with that, welcome to week 5 of our Gypsy Mentorship and Internship program for the patent application or patent drafting class. Our topic for today is filing patent application. So I'm sure we would have an interactive and an engaging segment or an engaging class from both our mentors and also from the sides of the mentees. I encourage you to to ask questions if you do have any. I also want us to have a very interactive session. You can use the chat box, use your emojis so that we know we have people who are active in the section. Thank you very much. So moving on, just to change the frame of how we operate. I would have called on our mentor to start the session, but then I would want us to start with mentees presentations first, right? I want us to start with presentation from the side of the mentees. When we are done with presentations, then we'll have Ms. Shukura do an overview for us of the topic for today, and then we'll take questions and answers. I hope that's fine by us. Right, okay. So please, we would like to have presentations from the mentees. So please, if the group presenter is on in class, please, I would like to kindly ask that you go ahead and start presentation on behalf of your group.
Okay. Um. Good evening, everyone. Good evening, Ma.
Yes, good evening, Esther. We can hear you.
Okay, please. I would like to firstly apologize for any noise that we may hear at my background. I'm in a kind of noisy place, but I will try to minimize the noise as much as I can.
All
Um.
right.
Please, could you help me to share the screen?
That's fine. Just kindly go ahead and introduce yourself while I try to do that.
Okay, so the topic for today's presentation is optimizing patent application strategies. We're going to be looking at a comprehensive analysis of filing, of the filing process, the duration, the priority consideration in both provisional, local, regional, and international contexts. So we'll be starting with the necessary provisions for patent filing. And the first thing we'll be looking at will be the steps involved. And the very first step involved in patent filing is, as we have been taught, is conducting a thorough search. Then after conducting a search, we cannot prepare, and we have found that okay, there's no prior art that is already the same with the invention we're talking about. We cannot prepare a patent application. After the application has been prepared, we cannot file it and then pay the required fee for filing. Then the documents that are required for filing a patent includes the application form, the description of the invention. We now have drawings and figures of the invention, the abstract, declaration of the invention, the power of attorney where applicable. That's if the power of attorney by the true inventor, stating that they allow the person filing to file on their behalf. They will not have the filing fees. The general requirement for filing, as we've also learned in the past, includes novelty, utility, and non-obviousness. Now, the advantages of the above mentioned includes priority dates. When a person has been able to conduct a thorough search, what happens is he has the advantage of knowing the already available patent applications that have been granted. So he knows whether or not he can gain priority in a particular, when it comes to maybe filing in regional aspects. Now, he can know whether probably in another country he will get patent for that, for the invention in another place. Then another advantage is also flexibility. Then it takes time to prepare, and the time it takes to prepare rather, and then it's less expensive when filing in your own state. So when someone wants to do other ones, like maybe the international or regional application, is usually more expensive than what is filed in the person's locality. Now we want to look at the local patent filing regulation using Nigeria as a case study. Now in Nigeria, the piece of legislation that governs Patent Design Act actually gives states or lays down some principles that or some hurdles that the patent application must cross before, or the invention must cross before it's even be regarded as an invention. And the first one is patentable subject matter. If the subject matter we're talking about is patentable. The second one is if it has an industrial application. The third one is if it is new. And as our teacher has taught us in the past, I think for my emphasis, the most important one actually is the patentable subject matter, because the object might have industrial application and other things, but if the subject matter itself is not patentable, then the patent will not fly. Then we have exclusions. The Patent Act provides for exclusion, and it excludes plant and animal varieties, and also inventions that contradict public order. So this kind of inventions cannot, even if they are new, they may meet other criteria, but then the subject matter is not patentable, so it cannot be patented. Then we now have the registration process. Now, the registration process in Nigeria, the first thing to do when someone wants to file an application is to go to the registrar of the Commercial Law Department in the Ministry of Trade and Investment Act, Ministry of Trade and Investments, pardon me, and file the application. Now, when the person wants to file the application, it's expected that the application will contain the applicant's full name and address, the description of the invention, and the appropriate plans and drawings to explain the invention. You also write contains you have to bring along with it the prescribed fee as I mean, signed by the patent. We've learned now, even from personal research, I've come to understand that a true inventor might actually be different from the person who filed the patent application. Sometimes they're not the same. They're not the same. So the true inventor and the person who owns the patent might be two different people. The sixth one is a power of attorney, authorizing the agents filing the patent on the behalf of the true inventor. Now, the lifespan of a patent in Nigeria is usually 20 years from the date the patent was granted to the statutory inventor. Now, the statutory inventor is the person who the department, that's the patent department, the department in charge of granting the patent recognizes as the owner of the patent. And like I said earlier, a statutory inventor may not be the true inventor. Now, we'll be looking at regional patent filing system, how it works in some regions. Now, there are some regional patent filing bodies, like like what we learned in the last class, that there are sometimes where you can actually file by region instead of filing only in a particular country. Now, the first of that is the European Patent Office, and from research is the most common type of the most common regional filing system, and of course it comprises of some of the European countries. Now, the advantage of going through this route, that's the European Patent Office route, is that you have a centralized application. So when the person applies through that route, the member states of that body, if it is granted, will recognize that patent. Then there's the advantage of translation. So you can actually be translated in different languages. Then we have the conduct of thorough examination of application. So when the person is filing, you don't have to start, like what our teacher has been telling us since the beginning of this class, that in Nigeria, more often than not, there is this, it's not so serious, let me put it that way. But when someone wants to apply to a regional board, of course you will take it very seriously. You will do a good job. So that's one of the benefits. It would push the person, to make sure that the application itself is a standard one. Then it also offers opportunity for oppositions and the challenge of the validity of the patent granted. If it's granted in only one region, in one state, for example, nobody's going to challenge it, especially if truly that's the first inventor in that place. But if there's a prior art in the region itself, the person who has the prior art will actually object to that patent being granted. Now, there are some challenges that can also come from going through that route, and the first of them is the maintenance fee can be high. Of course, that was one of the things we said in one of the things I mentioned earlier, that filing application in just your locality is less expensive than filing in a regional patents. And then it's also complex. So it's in a particular country, the patent application may meet the standard, and in another place it will not meet the standard. And when that's the case, the results might be a little bit complex. They also have, it limits the scope. So it does not cover every country, and that's true. It's not all states, and actually all European countries are member states of the EPO. So for those states, the patent will not apply to those states. Then we actually have one in Africa, which is the African Intellectual Property Organization. Sadly, Nigeria is not actually part of this organization, Nigeria and South Africa, but it includes countries like Benin Republic, Burkina Faso, and some other African countries, about 17 of them. Now, the benefits of this, just like the EPO, is that it has harmonized procedure. Then filing of the fees are in Africa are actually generally lower than the one of EPO. Then it also fosters economic, I would say, economic opportunity and innovation in Africa using, if you file through the African Intellectual Property Organization, is that you might have limited resources compared to the larger regional systems like the EPO, which could also impact the speed and the process and efficiency of the process. Now, infrastructure of intellectual property may also be less developed in some African states. Of course, we cannot compare the state of the development level of Africa with that of the European nations. The difference is glaring. So that could be another challenge. Another thing again is it will be limited to some countries. Like I said, so if someone goes through the African Intellectual Property Organization, now that patent may be granted by the organization, but it will not be applicable in Nigeria because Nigeria is not a member state. Now let's look at some international patent filing strategies. Now, when seeking to protect an invention in multiple countries, there are two primary routes a person can take. The first one is direct filing in individual countries. That is filing individually. You file in Nigeria, file in US, you file in UK. Another route you can take is going through the Patent Cooperation Treaty. Now, choosing the best filing for international patent, choosing the best route to go for international patent filing depends on some factors. And the first one includes the geographic scope, the budget the person has, the timeline, that's how quickly the person needs the patent. So some persons might want to file a patent for probably a grant or something, and they need it as regional route because that means granting a patent in that country will take so much time than other countries. They also have the quality of the patent, how strong the application is. Our teacher has always emphasized on the need to always prepare a sound patent, because even if it does not really, we don't have problem here in Nigeria, we might have problem of having the patent application flying in other countries. Now, another one again is the market analysis. Of course, when a person wants to apply for a patent, it should be in a place where the invention is needed. If you file a patent where the invention is not needed, it's a wasted effort. Now, in many cases, a combination of direct filing and PCT can also be effective. So the person now chooses, if the person has the finance to do it, you can decide to file in individual countries and then also file through the Patent Cooperation Treaty. Now, I want to look at the duration of patent process in some jurisdictions. And the first place I want to look at is the United States. Now, the United States, filing and granting a patent application takes about 2 to 5 years. The first stage, when you file, when the patent application is filed, what happens is it will take about 18 to 24 months for a first office action. That's when the first way they will look at the patent, not even talking about granting it now. They want to look at it to see, okay, are there things they need to reject? Are there things they need to that are to be objected to by in the patent? Now, if there are no objections after this period has elapsed and they've looked at the patent, what happens is it now takes about 3 to 6 months for the officers in charge to respond to the person applying. Now, after the response has been given to the person applying the patent, and the response is not an objection or any rejection of any part of the claim, it will not take another
Yeah. Hello, Chioma. Please, can you hear us? Hello. Hello, Chioma. Can you hear us?
Process now fully tied up.
It seems Chioma is having a little network issues. Hopefully she would. Okay, it's like she's back. Chioma, can you hear us?
Do you hear me? Can you hear me?
Yes, we're not hearing you
Yes, I
for a
can hear
bit.
you.
Yeah, so we're not hearing you for a bit. So please, you can carry on.
Oh, but can you hear about the duration for filing patent in some jurisdiction? And I just talked about the one for United States. Now I'll be going to the European Patent Office. Now this takes an average of also 3 to 5 years for the whole with has been filed. It takes a while for formal examination. They have to look at the patent, like just like the US, whether there are some rejections or objections to the patent, and they will be the applicant will receive a response within 6 months, and that response will indicate existing prior acts. Sorry. Now, after the search, an examination will not start. They will not start a substantive examination, because remember, this EPO is not just in one country, is regional. So they have to look at all the member states if the application will actually fly in those member states. Then, okay, because of time, let me quickly go to China. For China, it takes about one seem to be like the shortest, the one that goes with the shortest duration for filing and grant. The substantive examination takes about 18 months of filing. So they will look at the patent within like 18 months of filing the application, and then they will not grant it within 1.5 to 3 years. Now, the factors that will affect the duration of the filing and granting of the application in China is, of course, the examiner's expertise, the backlogs, and then how the person is able to fast track it. It almost these factors almost seem to play out in a number of the jurisdictions. Now, I want to look at prior dates and periods. How it's actually established. Now, the first filing date, the date of filing the application is granted. But now, another thing is the provisional application. In some jurisdiction, a provisional patent application can be filed to establish a priority date. And that's something that so for example, the person doesn't have you don't have the person's patent, you can file a provisional one and just reserve the date. But then the person has just, I think she mentioned about 6 months patent application. They will not have, the first is to determine, was this already in existence before the other person filed it? Is it really, really new? Not also establish originality of the invention. If indeed the invention we're talking about is original, it's just a copy of something of another invention. Another one is also to determine the scope of the patent right. So which area and which area does the patent cover? And our mentor has also urged us to make sure that the patent application is broad enough to cover as much as is new in the invention. Now, the impact of priority claims, excuse me, please. The impact of priority claims is priority claims allows the inventors to actually file the patent. So if the person doesn't have a priority claim, that means it doesn't have any local standard to even file any patent in the first place. Another one is it can help prevent others from obtaining patents on similar inventions by establishing that the inventor had the idea first. And the third one is determining the record of the inventor. Thank you very much.
All right, thank you very much, Yoma, for making that presentation on behalf of your group. Well done to you. I think you did very well on that presentation. Though we had a little issue hearing you, but all in all, well done to you and to the team for putting together that presentation. So we want to go over to Ms. Shukurat. Please, now you've had the presentation made by Chioma and the group. We would like to know what are your thoughts on it, and also we would like to get your discourse for today.
Hello, everyone. Good evening. How are you doing?
Good evening, ma. We're very fine.
So I think we should just hand over the session to Chioma to continue because she has delivered the session excellently well. So she's the new mentor for this session. So thank you for the detailed presentation. That was a job well done. Just to make one or two corrections. So instead of saying the ministry or the commercial department, you can just say the patent registry. That's easier for everybody to understand because most people don't even know that the patent registry is under the commercial department, under FMITI. So you can just say patent registry instead of ministry or the commercial department. I think you also mentioned something I wanted to correct. I can't remember what exactly. I can't remember what exactly. But so far you've done great. Okay, I think you didn't mention ARIPO. So while you were mentioning the regional steps, so the national step, like you mentioned, entails you filing in the national office of the country you like to get your application, your patent registered in. Then the regional registration is limited to probably a region whereby you have different countries or different member states who are members of that treaty or that convention. Now, those countries who are not member states to that regional convention cannot benefit from that, just like you mentioned. Nigeria, South Africa are not members of ARIPO, and as such, we can't file through ARIPO in Nigeria. So if we have clients in Nigeria who want to file application in other countries who are members of ARIPO, what we have to do is go through an agent whose country is a member state of ARIPO to file the application. And we have about 3 regional routes. We have EPO, we have ARIPO, and we have OAPI. The EPO is the European Patent Office. That's for patent. So when it comes, we are talking about trademark, it will be EU IPO. That's the European Union Trademark Office. Then we have ARIPO. ARIPO is the African Regional Intellectual Property Organization. And we have OAPI. OAPI is the Africa Intellectual Property Organization. It doesn't have regional. Please give me some time. So we have ARIPO. ARIPO is for the English-speaking African countries, and OAPI is for the French-speaking African countries. Also, most of these African countries have their own, should I say, For example, OAPI operates a unitary system. OAPI and EPO operate a unitary system, just like Chima mentioned. Is it Chiomara that Chima mentioned? And we have ARIPO. ARIPO does not operate a unitary system. So by unitary system, it means whenever you file in, let's say for example, OAPI has about 17 member states thereabouts. If you file in OAPI, it means it will be registered in all those 17 member states. But the same doesn't apply for ARIPO, because each member state of ARIPO have their own independent IP office. Say like Kenya, I think Kenya is a member state of ARIPO. Kenya have their own Kenya Intellectual Property Office. But for those who are under ARIPO, they don't have independent IP office. And because of this, whenever you file in OAPI, it covers all the member states of OAPI. You don't need to designate. It covers it automatically. But for ARIPO, you still have to designate which member states do you want your application to be filed in. So OAPI and EPO works the same way. They both operate a unitary system, unlike ARIPO. ARIPO does not operate a unitary system. So back to the IP strategies, like you mentioned, you have so when you are looking at filing of an application, you want to look at what are you filing, where do you want to file, when do you want to file. So all of this will give you a very good starting point of what to do, and it's all boiled down to, so how do you want to file? Do you want to file in a member state who is part of the Paris Convention, or do you want to go through PCT? Do you want to file nationally? Now, I think we have about 153 member states for the Paris Convention. Still, not all countries are member states of the Paris Convention or PCT. That's why the PCT is not called a worldwide patent application, because not all countries are members of PCT. So for Paris Convention, the same thing applies. Not all countries are member states of Paris. Nigeria is a member state of Paris. So we are able to enjoy the benefits of national treatment and priority, grace period. So those countries who are not member state of the Paris Convention, if they file an application, they won't benefit from the treatment that the Paris Convention offers, such as the national treatment, the priority date, the grace period, and so on and so forth. They won't benefit that, because only the Paris Convention offers that. So those who don't have that benefits, because they are not part of Paris Convention, if you file in their individual states, you won't be able to claim priority, or claim, or maybe use grace period, or maybe in fact file provisional application, except if these are captured in their own laws. So some countries who are not maybe members of some of these treaties, some of them have adopted these treaties into their own national laws. So even if they are not members of probably Paris, they might still be able to enjoy some of these because it has been adapted in their law. Or maybe they have maybe bilateral or multilateral agreement with member states who are members of Paris Convention. So when they don't have a direct membership, but they have these multilateral agreements or bilateral agreements with member states who are members of Paris Convention, through that agreement, they can also enjoy this, because they will be able to benefit from the multilateral agreement or bilateral agreement. So these are some of the things you want to put into perspective. Then also, not all countries provide for provisional filing. Like Nigeria, our Patent Act does not explicitly mention that you can file provisional application. But I know I once asked a question about that from the then patent registry. So what she said was, you can file, but they don't call it provisional. Okay, so it depends on probably what you agree when you are filing. Then for what else do I want to talk on? Yeah, for grace period as well. Not all countries also give you grace period, because most times, like the Paris Convention has already given its own law, then we have the TRIPS agreement also adopt some of these laws and even expanded on it, kind of, and giving a minimum requirement as well. So there are some countries whereby, for example, in Nigeria, if you probably showcase your product or your patent, sorry, your invention in, let's say, during an exhibition or someone way or the other, it was showcased by you and you haven't filed your application, you still have, according to the law, you have about 6 months, is it 6 months or 12 months grace period for you to file before you that application, before that disclosure is going to, invalidate your application. But in some other countries, they don't give grace period at all. There are some countries that give grace period, but the occasion is specific. Some countries don't give grace period if you, the inventor, go ahead to showcase your invention. So you have to understand the laws of each countries, and that way you are able to know what's up with that country and when and where to actually file your application. Do I have any other thing to add? I don't think so. I think that will be all from my side. So probably could take question. Then if you have questions to address some of the questions, then fine, we can dive into that as well. So over to you, moderator.
All right, thank you, Ms. Shukurat.
You're welcome.
For those highlights that you gave. We're really happy to hear from you, and also we're also happy to hear from our speaker who gave the presentation. So please let's take questions. We want to have an interactive question and answer segment so that after that we can just, I think it's going to be safe for us to call it a night to class. So please, do we have questions for our mentor?
Yes, I do.
All right, please go ahead, Tony.
Good evening, Ma. Good evening, everyone.
Good evening.
Ma, please, if you have a client, or rather, let me just be sincere, I have a client that has an invention, but however, he published it in an international journal for scientific research and management 3 years ago. And
you know what they call it, don't cast.
And now he wants to apply for TED Fund exhibition that is coming up in November. And is now he realizes that he has a right before he can partner with the Nigerian government. Should, in case his prototype be picked for the exhibition, he wants to protect his rights. Is there anything we can do to, will I say, mitigate his loss?
At this point, there's nothing you can do with respect to patent, because you are supposed to file before disclosing. And if peradventure you disclose, you only have about 6 or 12 months period before you can even file. So 3 years, no, that's you can't even file again. The only thing the person can actually do is probably find a way to, I don't know, maybe upgrade or update something about the invention and probably file a patent for that, or file a utility model, because it won't be new again actually. So you won't be able to file a utility model, because utility model requires that your invention is new and industrially applicable, even though it's not inventive. But in this case now, 3 years is no longer new, so you can't file for that again. I think the only thing person can rely on now is contracts. Probably get a contract to sign that, oh, I own this invention. If it's exploited, I get a percentage, or you should not do this or that. But with respect to patents, you can't have that again. It's far gone.
Okay. However, what I did is search after you told us last week with the patent scope.
Okay.
The invention here, it's actually a modification, or will I say an expression of an IoT device. So the invention itself, it's not novel. but it's the applicability of the invention. So is there still hope for him?
The applicability, is it a product?
Yes, it's a product that even has a process attached to it.
What the thing is, if it depends on what was published. What was published, did it publish the process as well, or just the iOS? Because like I said last week, you can file a patent for either a process or a method, or you can file a process by method or method by process. So in this case, if what was published is just the product, I don't think there's a way you publish something about a product and not mention the process.
Process. He actually did mention the process in
So
the publication.
except there's something that he has not, that wasn't captured in the application, in the publication, that could actually help his application. Because when it comes to disclosure, like I said, something as simple as social media post can invalidate your application. So
Yes.
publication, journal, exhibition, anything, article, patent, they are all referred to as prior act. So it has a slim chance, actually.
Okay. Thank you, ma'am.
You're welcome. Except maybe he probably could, I don't know, if it's an application, you could probably do a copyright for it. Since copyright doesn't have novelty, it has more like originality, and there's no limits, or there's no limitation to maybe file when you get the idea or something like that. So you could do a copyright for the expression of the idea, and maybe a non-disclosure agreement to back it up.
Okay, ma. Thank you, ma.
Yeah, you're welcome. So I don't know if I made a post on the recent case about Lagos State government stealing somebody's idea. Let me say somebody expressed idea. It's on LinkedIn. It's also on Instagram. So you might want to get one or two things from that.
Okay, ma. I'll do just that.
All right.
Thank you.
You're welcome.
Right. Thank you, Tony, and thank you also, Ms. Shukurat, for helping us with that question and answer. So please, do we still have any more questions from the mentees?
Yes, I do. Good evening.
Good
Yes,
evening.
Good evening, everyone. Good evening, Lady Shukurat.
Good evening, Bezid. How are you doing?
I'm very good on you. Thank you, ma'am.
Fine.
A quick one. You made mention of NDA.
Okay.
I'm a little bit confused because how would there be an NDA for a procedure that has already been disclosed? Because the whole essence of NDA is for secrecy.
Yeah.
I don't know if that's my question.
Like I said, even if you publish something, when you are probably going to make it work, when you are going to put it into workings, there might be one or two things that you're going to do that wasn't published, or that wasn't that didn't come, that you didn't write during publication, more like a technical know-how. Okay, a technical know-how is someone that knows about it that is going to bring that in. It might not be captured in the publication. So like I said, it depends on the invention and how technical it is, because there are sometimes, just like we have trade secrets and patents, sometimes there are some other things that even after you file a patent, you might still have a trade secret for some things that wasn't captured maybe while you were filing a patent application. So if it has something like that, they can have an NDA.
Thank you.
You're welcome.
Thank you, Blessed, for that question. So we are still taking questions. I think we can still take maybe one or two. So do we still have questions for our mentor? Any other person with any question? All right. Okay, in the absence of any question, I would just like to say this is, I think, officially for the patent class, this is the last class we are having. right? On Sunday, the subsequent classes are going to be combined classes, and then subsequently we'll be having the closing ceremony and the in-betweens and the things and the other things that will play out in between. So just before we round up the session, Ma, I don't know if it's going to be possible for you to give some of our mentees like a word of encouragement in that sense, as you know, as they seek to build themselves within this space.
So what should I say? How many lawyers do we have here?
I'm
Are
a
they
lawyer.
okay? Do we have like do we have all law students? Do we have engineers here? Do
I'm
we
also a
have
lawyer
I'm
here.
a lawyer too.
so
I'm
everybody
a
here they
lawyer.
are lawyers? Wahala. Now, wow.
Law student, ma'am.
You said what?
Choma is a law student.
Everybody is studying law. I think I'm the only different person here anyway. So what I would say is, I think you need to understand your why and why exactly it is you are doing it. Because I can see that after I leave here now, I'm going to see different tags and comments and all about this session. But it's also understandable for you to know why you are here. It's not really about the certificate. It's about the knowledge. Sorry. It's okay. So it's about what exactly it is you are doing. And I want to say that it's not advisable for you to take course haphazardly. Like you've taken this patent course, I think the next question for you is what next? How else do I advance my knowledge on patent drafting? Do I just want to fly from patent drafting to go and take another course on trademark? Then in the next 2 months, you are taking another course on copyrights. So you need to understand your why. So for me, when I started, I didn't have any intention to be an IP consultant because I have a very shy personality. So my intention was I just want to be okay. I have my family and, just stay low key and, live the good life. But apparently I was employed by the federal government, Federal Institute of Industrial Research, Oshodi, and I was posted in the IP department. So that was how I started my IP career. I actually studied horticulture. And for IP, you really don't need a particular field to study IP. You just need to understand the basics and understand how it works. So I posted to the IP department, and that was how I started. And fortunately for us, the WIPO courses are free for government parastatals or government staff. So because I'm a government staff, I was able to, get my portal up on WIPO's platform. Then I started taking WIPO courses. I think I started my first course back in 2018. Yes, 2018. And today I can say I've taken about more than 20 WIPO courses. But what helped me specifically was because most of the courses were free for government workers. And because of this, you'll just have time, take the course, do this, do that. Now, I understand from your own aspect that you might not be able to take most of these courses because majority of them are paid. Say, for example, you want to take DL 301, which is the WIPO course on patents. It's paid. For students, it's $40. For professionals, it's $60. Another thing I would say is don't shoot yourself in the leg. Say you have a WIPO platform already, and because you are looking at the money, instead of you to register as a professional that you are, you go and register as a student. There are some courses that are not available for students, but are available for professionals. So you want to build your profile looking ahead, not just because of what you want to get now. Although it's possible for you to still go to your portal and probably change the settings from student to professional. So what I would say is while you are taking, because I think JIIPCC is the only platform organization that I've seen that is doing patent drafting. Although there's MIPLG, they do just normal series, talk about IP, but for patent drafting, we really don't have much, right? And I'm doing this because I have, I don't know, Maybe because my organization is a research institute. So what we do is we work with the researchers, get their inventions patented, and file the application in the patent registry or with NOTAP. So I have more interest in patent because that's what we work on day in, day out. So what I've done so far is I have built myself in that patent line, despite the fact that I didn't niche down to patents, but I know that I have more interest in patent because it's what I do on a daily basis, right? And you know, we have this when it comes to technology transfer, we have this gap because yes, we have the inventions, but you can't find most of these inventions in the market. So that's another place you want to put yourself in. You want to put yourself in a place whereby people are is still coming up. So by the time people eyes are open to that space, you already have a grounded feet in that area. So what I did was, and if you want to take WIPO courses, you have to be consistent and know where you are going to. There are sometimes you have opportunities to take WIPO courses, but you'll be required to upload some certifications. And let's say you want to take WIPO course on the patent examiners for African countries. You must have probably done DL 101, you must have done DL 301, you probably must have done DL 170, DL 177. So you want to like go that route. Don't take patent today and tomorrow you are taking copyright. Next tomorrow you are taking trademark when you know that you have interest more in patents. So it's not like you should not take other courses. I've taken maybe more than all these courses, but my professional line is on patents. So I've done the WIPO course on international patent drafting that we had to travel. I've done the one for patent examiners. So I'm currently doing the one for patent examiners in Africa. So you want to build your portfolio because yes, our patent system in Nigeria is not yet there. But what if we get there? Who will be the people to lead when we get there? So you want to be ready so that when the opportunity comes, you are ready to take the opportunity. Or better still, it might not even be in Nigeria. It might be applicable in any other country that are doing this substantive examination and so on and so forth. So just know where you're going to and plan towards it. So lastly, what I would say is, how many of you have taken WIPO courses? Do we have anybody that have WIPO certificates? Let me raise your hand if you do. Anyone is WIPO certificates? Like, I don't think we have anyone. So I'm currently running a pilot project with WIPO. It's a pilot project, that's why it's not outside there. We are taking I think we have about 57 registered students, entrepreneurs, professionals who will be registering for the WIPO course, the WIPO DL 101 in October. The course should end in, I think, November. Then depends on how it turns out. If WIPO decides to continue this course with us, by next year, I'll probably be reaching out to JIIPCC so that if you have interested people who would like to take the courses, you'll be able to also register and take the course, then get your certificates after writing your exam. So that way you can start building your portfolio and you also have a broader knowledge on IP. Okay, somebody said she registered. Okay. You register?
Register.
You said what?
I'm interested. How do I register? I'm interested.
Okay, how do you register? It depends. Because what happened is when you register with WIPO, you are more like on your own to take the course. But the way we are running it is like the Tangible Nugget in collaboration with WIPO. So what we do is you register under the Tangible Nugget. After taking the WIPO course, then we'll be doing like a weekly session with the students. If you register strictly with WIPO, you will not have that. You have to just read on your own. So if you would like to wait for the next session after this pilot project, then possibly you'll be able to register, then probably take those sessions with us so that when you're writing your exam, it's more easier for you. You have more understanding of the course. So I'll reach out to JIIPC when it's time. Yes, the one for the collaboration, the pilot project is closed for now. That's what I was saying. So probably next year we should have the second project. The one for the first one is closed. The names have been selected, emails have been sent. So let's see for next session. I'm going to reach out to JIIPCC and they will let you all know.
Okay, ma. Thank you, ma.
You're
All
welcome.
right. Thank you so much, Ma, for those words, those your kind words. Thank you so much for everything you do in this space and how much you contribute to our knowledge here in JIIPCC. We are truly, truly, truly grateful. So yes, so I just want to encourage all the mentees here to take advantage of what Ms. Shukurat has said. When she does reach out to us, we'll do well to share the information with the general class so that if you are interested in that opportunity, you can take advantage of that. So like I said, this is our last class for the patent drafting class, and it has been wonderful sharing this particular session with you. We look forward to seeing you guys in the subsequent sessions that we hold on Friday and Saturday next week. The informations and the tasks for the week will be dropped in your group this evening or tomorrow morning. So please pay attention to the group. Thank you very much, Ms. Sukurat, for your time. Thank you so much for these 5 weeks. You have been consistent and you have been with us. You have not abandoned us in that sense. So we are really, really grateful. Thank you very much, Ma.
We need more patent experts in Nigeria. So yes, of course.
Yes, Ma, thank you. So hopefully in subsequent quarters, we'll be able to get more professionals in this space who will be able to also help out with the sessions and also so that we can have a broader sphere of knowledge within this space. So just before we go, as usual, please we would like to take a quick screenshot of today's class and then for our social media postings, and we'll call it a night. So please, I would like to ask if it's possible, can we have our videos turned on? All right, thank you, Ms. Shukurat. Can we have any of the mentees turn on their videos, please, if that's possible? Thank you, Esther. Thank you, Blessed. All right. All right, thank you very much, everyone. We've come to the end of today's class. It was nice having all of us in class. It was nice hearing from our mentor, and it was also nice hearing from the mentees. Thank you for your questions, and also thank you. Okay. Thank you for your questions, and also thank you, Ms. Shukurat, for addressing and answering our questions. We've come to the end of today's class. See you guys next week, and goodbye. Take care, everyone.
All right, bye.
Bye, ma'am.